Okay, good evening, everyone. Welcome to week 10. We're well and truly in the thick of it now. The assignment's been released for almost a week, and so there's just over a week until that gets submitted. So I hope you're all beavering away on that one. I know that it's at the point in the semester where everyone's got a lot of things on. So if there are things that you need to talk about or questions or concerns that you've got, please definitely do get in touch, because I do understand that everyone does have a lot on at the moment, but hopefully you're all enjoying the two report questions. They try to give you a few interesting issues to talk about, so hopefully that's all progressing well. This week we are talking about the consumer credit and especially the National Consumer Code. And there's not really anything too much that I wanted to kick off with. It's a really broad topic, but it's also, I think, fairly logical for the most part in the way that it structures itself to try and protect consumers. And certainly in light of the Royal Commission into Banking a couple of years ago, we can question how well the code succeeds in some of those areas, but for the most part, in trying to wrap our heads around the basics of it, at least, it's all fairly logical in what it's trying to do and how it tries to achieve that. So there wasn't really anything that I necessarily wanted to cover, and I just checked before I started the recording. There didn't seem to be anything else that anyone else particularly wanted discussed. So we might just jump straight into the first problem for this week, and that'll give us a few things to talk about and a few departure points for discussion as well. And so problem one asks us, what is the procedure for a credit provider enforcing a mortgage over goods? So what are the steps? What are the kinds of considerations that we're interested in here? And there might be more to it than we think at first instance. So what do you guys reckon? What's the process? So starting with the default notice. Yeah, absolutely. So I guess, in the very initial, to kick things off, we want to actually make sure that the debtor is in default. We're not going to start these proceedings if payments are all ticking along normally. But assuming that, we start with a default notice. And what's that about, and what's that aiming to provide?
To let the debtor know that they are in default and to give them 30 days to remedy that default?
Yep. So letting them know there's a problem and you've got 30 days to fix it. Yep. What else does it do?
It should inform them of the process for applying for hardship.
Yep, absolutely. And that's, I know I keep talking about coronavirus, but it is kind of the pervasive issue, especially when we think about commercial law at the moment. But the ideas around hardship at the moment, with everything that's going on, probably forefront in a lot of people's minds. But so this notice is there to say, we have noticed that there's a problem. You've got 30 days to fix it. If there are things going on in your life, in your financial situation, that are making payment hard, there are options. Please, review those. Please have a think about whether those apply to you and things like that. Yep, absolutely. So the default notice needs to make the debtor aware that there is a process for that. Yep. Does it need to do anything else?
Puts the debtor on notice about credit reporting agencies?
Yes. Yep. So in terms of their privacy, making them aware that, that information could be passed on. Yep. One more thing that I'm thinking of as well.
The action necessary to remedy the default?
Yeah, so there's the action in terms of, you know, you need to pay us this amount by this time, is part of it. Yep. And also letting the debtor know that if they continue to be in default, they might not get another notice. You know, you tend to get sent another notice anyway, but technically there's no requirement. The enforcement proceedings can start from the end of that 30-day period, and there's no requirement for another notice to say, look, you're still in default. And so just letting the debtor know, you know, if you don't hear from us, that's not necessarily good news. And so all of that, the logic behind all of those provisions is, well, one, making sure that the debtor is aware of the situation, letting the debtor know their rights and their obligations, and letting them know the process from here and what the consequences will be. So just trying to be really clear with the debtor is, you know, is the logic behind all of that. What else? So we've talked about the notice under Section 88. What happens, let's say the 30 days pass, what happens after that?
There a notice of repossession?
Yep. Tell me more.
The notes that I've got here is, so it's to put the debtor on notice that the creditor wants to repossess the item that they hold security over, and then they need to hold that item for like a period of it's either they need to hold it for a period of 14 days, or within 14 days, they need to let the debtor know what they intend to do with the item, and the debtor has an opportunity to essentially buy it back or to remedy their default. Otherwise, after 21 days, the mortgagor can then sell it or do whatever they need to do to try and recover their costs.
Absolutely. So it's, again, really just trying to keep the debtor informed and in the loop and letting them know what the consequences are. But yeah, just outlining the process. These are the goods that we'll be repossessing, or the items that we'll be repossessing. This is your last chance to, you know, do something about the debt before we have to take our own action to get our money back, kind of thing. Does, in the question, enforcing a mortgage over goods, does that bring to mind anything else that we talk about in this week's topic?
You mean like the personal property securities? Yeah.
PPSR, absolutely. Yeah. So there's sort of the fact that this is a mortgage over goods as opposed to a mortgage over land or property in the term, like real property, alerts us to the fact that potentially we're dealing with the PPSR as well, right? And so in particular, having been alerted that the PPSR might be at play, what are the types of things that we're thinking about here, if that's the case?
Whether the security for the mortgage has been perfected.
Yep. Does someone want to share what perfected means?
It means the mortgage over it is registered on the PPSR's registry.
Yep, excellent. So is the mortgage over this thing perfected? Is it registered under the PPSR? And if it is, then that's a good thing, that's a bad thing. What happens next?
Like perfection basically gives preference for the mortgage over other potential claims on the good.
Yep, absolutely. And so if you're, I mean, you would have done this beforehand, but if you're the creditor and this person's in default, you've given them the 30-day notice, but you're not just going to sit on your hands. You're thinking about, okay, if we do have to start enforcement proceedings and things like that, what might be something that you're looking at doing?
checking the register to make sure that you hold the I guess the highest level of security over the item?
Yeah, absolutely. And I mean, you would have done that when you gave the credit in the first place. But yeah, finding out where in the rank of creditors you sit, because and this comes under the sort of default enforcement provisions under Section 55. If you are a lower ranked creditor, but you're the one that start these enforcement proceedings, you have an obligation to pay out the higher ranked creditors before you get your own money. So yeah, you'd want to do a little bit of background research to find out where you sit in the scheme of things. And I thought what we could do, just as a brief detour, is have a little look at the PPSR website. And I spent many a formative year. Timed out. Okay. My early days as a lawyer was just when the PPSR had just come out, and so a lot of my early work was porting over old contracts into the register and things like that. So it's a bit of PTSD to look at the website again, but just to sort of show you around. What is really interesting about it is there's a specific section just for motor vehicles, but then for other types of goods as well. But what you can actually do is, once you've got the VIN or the chassis number or whatever details, depending on the type of good, you just type it in, and it only costs $2 to do a search. It used to cost $18. And then you put all the details in, and it will give you a certificate that's got a list of all the different securities that are registered against that good, the order in which those securities rank or have been perfected. So it very much does function like the sort of real properties register, the Land Titles Act and all that sort of stuff, but for movable goods. And so it is designed to be really clear. It's designed to be really great. And it's cheaper than it used to be, which is really good. But that's just to sort of show you around. There's really not much more to it than that, which is good because it makes it nice and simple to work with. Yeah, I think that's all I wanted to say about that, just to give you a quick show around the website, and to be thinking about, if you were in the position of a creditor, obviously you want to know where you're ranked in all of these things, but also as a potential third party, it is good to, and this is obviously detouring a little bit from our consideration of enforcing a mortgage. As a third party purchaser of a good, you can also search. And I remember having clients who, were looking at buying a car and, have you searched the register? No, it's brand new. Of course I haven't. And you do the search, and then they would go to the seller and say, okay, well, I'm assuming that this is just your car loan. And then, it was interesting the kinds of things that people came back with. They would come back with the price of the car was non-negotiable because that was the price of the loan that was still out on it, rather than actually any kind of true value of what the car was worth and things like that. So it does actually feed into people's decisions about whether to make a purchase, feeds into, a creditor's decision whether to loan money, all that kind of stuff. So it is a really useful tool, and one, even if you don't go into commercial practice, still is going to be potentially useful to you at some time or other. So that's that one. Any questions about that before we move on? Excellent. Like I said, it's nice and clear, and yeah, really straightforward to use, which is good. So you've checked the PPSR. you're first in line, which is great. And so that gives you, sort of the green light to move ahead with enforcement if you needed to. Are there any other things that we need to think about or consider in enforcing a mortgage over some goods?
The value of the outstanding debt, like if it's 25% or less than $10,000, you have to apply to the courts if you want to repossess the item.
Yep. So thinking about the value, the value of the property itself, and then also the value of the debt that's left. Obviously, there's the limit. If it's, there's not much debt left, there's special procedures. And obviously if there's, not much left, but more than that limit, thinking about what to do with sort of excess funds after you've sold it off, and how that gets distributed either amongst other creditors or back to the debtor. Yep, absolutely. Anything else? I think that pretty much covers it. There's obviously, things to think about in terms of how the debt is actually, how the property is recovered, how it then is sold and things like that. But in terms of for our purposes under the National Credit Code, that's, those are the basics. So I'm happy for us to move on from that, unless there's any other lingering questions or concerns. Cool. All right. Let's jump into question 2, which talks about Tony is a bricklaying subcontractor working through his company Tunbrick Proprietary Limited. He needs a new ute for his work, but decides to get a dual cab vehicle so that he can run his family around as well. He has young children, and the vehicle is used to drop them at school and to transport to music lessons and sport. Tony buys the truck through his company for tax reasons. The price from a dealer is 25 grand, and he pays 15,000 cash and agrees with the dealer, who often makes these kinds of arrangements, to pay the balance in 2 monthly instalments of $5,000. Will the National Credit Code apply to this transaction? Let's get a quick whip around of everyone, either verbally or in the chat, just a very quick yes, no, and then we can talk about the reasons why you think so. We've got a no, maybe, but probably not, no, and an I don't think so. So we're leaning more towards no than yes. Okay, let's talk about why that is. So, and to do this, we're really going through sort of a shopping list of what does the NCC apply to. So what's the first sort of step in that sort of thought process? So with talking about, was this bought for business purposes or not? Yeah, that's definitely part of it. So let's talk about that first. What sorts of purposes will the credit code apply to?
Under section 5, it sets out rather clear criteria. So subsection 1A there is that it has to be a natural person as the debtor, and the facts suggest that this was bought through his company. So that's the first hurdle. Mm-hmm.
Yep. So straight out of the box, where we fall at the first hurdle because the code applies to natural people, and Tunbrick Proprietary Limited is not a natural person. So that one's a problem straight up. Then moving on in terms of section 5.1, thinking about the purposes of the loan. Are business purposes okay?
Do you want me to keep going, or does someone else want to jump in?
I'm happy for whoever wants to answer.
So under subsection B, it sets out the predominant purpose. So it has to be wholly or predominantly, and there's some case law around that, but it's essentially personal, domestic or household purposes, or in respect of residential property for investment purposes, or to refinance for a residential property, whether that's for personal or investment purposes.
Yeah, absolutely. So we're mostly interested in the first part there, in terms of credit provided for wholly or predominantly personal, domestic or household purposes. And so the issue for us is this ute that's been bought, is it being used for, we know it's not wholly, but is it for predominantly personal, domestic or household purposes? And what does the Act say about determining, when the good is used for multiple purposes? What's the rule?
Well, subsection 4 is, it says that the predominant purpose is where more than half the credit is intended to be used for that purpose, or where the credit is intended to be used to obtain the purpose for which the goods or service are intended to be most used. Sorry, I jumbled that all up. It's basically the cost, if you're using more than half the money on something, or whether you're going to use it most of the time.
Yeah, so it's so there's sort of, the two parts to that. So if it was, if Tony had been given a loan for $10,000 and he spent he used $6,000 of that loan to buy one thing that was, if he bought a $6,000 sort of Sunday drive car and then a $4,000 work ute, then in terms of the $10,000 loan as a whole, he's obviously used more than half the credit for personal purposes. But here we're on to the second part of subsection 4, because it's the one good, all the credit amount is being spent on the one item. And so we're trying to determine whether that has been predominantly used for a personal purpose or not. And so there's a little bit of leeway and discussion to be had there. Do we think that this sounds like it's being used, it's most intended for work or for personal use?
Personal.
You think personal? Why is that?
I'm not saying he's using it to drop the kids off to music lessons and sport.
Yep.
He buys it through his company for tax reasons, but it's not really saying that he's going to be using it mostly for work. It's sort of like a mixture. He needs it for work, but he gets a dual cab because he needs to run his family around. If it was just for work, he might just get a single cab.
Yep. So we're sort of thinking that the reasoning behind buying this particular vehicle was because he had family purposes in mind. If he was thinking mostly about work, he would have bought a different type of car. Okay.
Yeah. Well, both of them, you could say that it's both personal and work. I'm just trying to pick a side of the fence instead of sitting on it.
Yeah, no, that's fair enough. Another way that you could look at it is to try and, maybe look at the mileage that he spends for each purpose. If he drives it, a long distance each day going to and from work, and then only a short distance to take the kids to music and sport, that might be one way of determining it, or the frequency of use, things like that. So all of that could go to thinking about whether it was intended for. We've also got an interesting. Oh, sorry, I should let anyone else weigh in on that debate too if they want to. What do we think that this ute is mostly intended for? So the other debate to be had as well is whether we need to take into account what the credit provider understood the purpose to be, or whether we should be looking at the substance of the transaction and actually looking at, okay, he's bought this car, and whatever the credit provider thought were his reasons don't matter. What we need to do is focus on the transaction itself and then how it's been used subsequently. What side of that debate do we come down on, or should we be coming down on?
I think the law is rather unsettled with that. I read a recent decision, I don't have it in front of me, it involved the Commonwealth Bank, and there was some good commentary from the judge in that case, which called out the fact that, do you consider it from what the bank was told by the customer or from what the customer then went on to do with the money? And in that particular case, they were saying that you need to look at it from the perspective of the lender. So yeah, I think it's really inconsistent, but it can give a different outcome depending on the facts.
Yeah, absolutely. So it's tricky because the courts don't quite seem to know what direction they want to go in, and you're absolutely right. It can very much depend on. It can very much influence the outcome of the case, because what a lender is or isn't told can be very different from what is in the debtor's mind. Sorry, I'm just looking in the chat. Kathleen's added, taking into account the information communicated by the consumer to the credit provider prior to and at the time of the credit contract was entered into. Yeah, so thinking about what the consumer or the debtor communicated to the creditor and said, this is why I'm buying this, can be important. The other perspective is to look at well, what was the substance of the transaction, and there was a line of cases that seemed to prefer that line of reasoning, and Knowles and Victorian Mortgage Investments is a particularly interesting case to have a read of if you get the chance, just because of sort of the lengths and the very, very broad approach that the judge takes, and the discussion about this is a piece of legislation that should be read to benefit as many consumers as possible, which is an interesting take on this discussion as well, and one that's maybe not always supported by our ideas about what judges should or shouldn't be doing, but it was an interesting perspective to say, well, let's try and include as many people as possible in this, and so what gets told to the creditor maybe doesn't matter as much as what the consumer actually uses the money for, if it would bring the transaction into the code's application. So unsettled law there, which does provide a good little area for discussion and debate, and weighing up both approaches, and also weighing up, well, what's the outcome likely to be if we prefer one test over the other, and if we're representing Tony, obviously we've got other issues with other parts of the Act's applications, but if we're representing Tony and we want him to be included under the code, thinking about, well, the credit provider probably thinks that this was a work ute because he's bought it through the company, and he said that's for tax reasons. But if we could say, sort of going off James's argument about, well, he bought this particular car versus another one, that might indicate that the substance of the transaction shows, an intention for this to be predominantly personal use or something like that. So talking through those issues is really interesting and important. Is there anything else that might be relevant to the purpose of the loan, or that might affect the code's application here?
Whether there was a fee for the credit. So on the facts, it just talks about the repayment installments, which suggests there's no interest, but was there any other fee?
Yep, absolutely. So we'll circle back to that because that's sort of, going on to the next separate issue, but you're absolutely right. But before we get into that, what would be the impact if Tony had signed a declaration of purpose? Here we go. Yeah, Kathleen's put it in the chat from Rule 68. So if Tony had signed, if the car dealer had presented him with a declaration of purpose that says, I am buying this car for predominantly business purposes, what are the implications of his doing that if he had done that?
The presumption is that it's not under the NCC, but it obviously can still be argued that it is.
Yep, absolutely. So presumption, which means that it's not set in stone, but it gives us a starting point, is the view that the code wouldn't apply because the consumer is saying, I'm not buying this for personal reasons, I'm buying this for a business reason. And therefore the code wouldn't apply. What might be some of the reasons why that presumption would be set aside?
If the lender knew, or if they could have known by making reasonable inquiries that the loan was actually for a personal purpose, despite the Rule 68 being signed?
Yep, absolutely. So, and I think given that this is still a ute, just a big one, it would be probably a little bit difficult to argue in this circumstance that the car dealer should have known that it wasn't for a business purpose. But if it was, if it was a different sort of car, then perhaps that might clue us onto setting aside the presumption and thinking about, okay, well, this isn't the type of car that people normally buy for a business purpose or for a work purpose rather than for personal or, taking the kids to school and things like that. Yeah, if it was one of those big sort of soccer mum vans, the presumption might be that this is for personal use rather than for work purposes. And so signing a declaration of purpose for that car maybe wouldn't fly so much. Kind of makes you wonder how purpose being decided after will work with Rule 68. So are you sort of saying if you've signed a declaration and then it turns out that the presumption should be set aside, you would expect then that in terms of thinking about Section 5, the personal and domestic purposes, you'd expect then that would flow on and say, yes, this is for personal and domestic purposes. Is that sort of what you were getting at with there, Kathleen? It would be sort of hard to set aside the presumption but then find that it was for work purposes anyway?
No, just saying that if you use this second way of working out the purpose as, you know, what the consumer bought after they got the money, well, then you wouldn't be able to use a Rule 68. So wouldn't that more speak to the fact that the purpose should be what's communicated before the credit is provided?
Yeah, that's a good point. It's tricky because it probably depends. I mean, it always depends on the facts of the case, but really hinges on whether one of these declarations has been signed or not. If there is a declaration, that sort of sets you down one path of inquiry that, potentially doesn't lead you so much to a question of which test should be preferred. Whereas if there's no declaration of purpose, then you probably are jumping more into, okay, well, what was communicated to the creditor, and does that have any bearing on how we understand the purpose? Does that make sense?
No, I didn't mean that. I just meant in using statutory interpretation to think of whether or not the purpose of the act was for the purpose to be defined before or after the credit was provided.
Right. Yeah.
Rule 68 kind of makes you lean towards that, you know, that the legislators actually meant it to be decided prior. But anyway, it was just a thought, that's all.
Yeah, no, that's a good point. Yeah, sorry, I jumped down and ran with your thoughts a little bit too far, perhaps. But yeah, no, that's a good point. Is thinking about sort of when the code was drafted, sort of this wasn't meant to be an issue, and yet it's become one. Absolutely. So we've talked about natural person. We've talked about what the purpose was for. Let's now then circle back to Mo's point about a charge for the credit. How might that sort of play out or be an issue here?
So I was referring to the meaning of credit. So that there's a requirement for the code to apply that there needs to be some sort of charge for the credit. So it doesn't have to be interest. It can be some other charge. So the facts suggest that there was no interest because the installments add up to the total. But say, for example, if there was like an admin fee of $50 for setting this up, that may then bring it within the scope of the code had he taken the loan out in his own name and the other elements of purpose were there.
Yep. So putting aside all the other issues, we have to consider whether there was a charge for the credit or not. And the facts really don't say that there is one. So we'd probably conclude that there isn't, but we'd obviously want more information just to double check that, just to see that, there wasn't some extra fee or charge incorporated into things. But definitely in terms of whether the code will apply or not, we're probably leaning more towards it failing on that issue as well. What's next?
The course of business of providing credit.
Yep.
So that's under subsection D. So I think the facts lean towards that in saying that the dealer makes these sorts of arrangements, suggests that they provide credit in the course of their business.
Yep, absolutely. So finally, we've got one criteria that seems more to be ticked off than not ticked off. The credit provider has to do this in the course of business. And here we know that the car dealer, one, is operating as a car dealer rather than, it's just a private seller as a one-off selling their car. So they're operating as a car dealer and they make these kinds of arrangements all the time. Would lead us to think that this is done in the course of business, which also invokes the whole range of issues around, does the car dealer comply with all the licensing requirements and regulations and things like that? which the facts obviously don't tell us about. But, you know, if they're doing this all the time, then perhaps we can assume that they're fine on that front. What else? How, apart from sort of the issue of interest, does the way that the repayments are made clue us onto anything interesting?
Oh, whether it's short term.
Not what I was thinking of, but potentially.
Oh. Sorry.
I don't think the facts say when it was due. 2 monthly installments. So I guess, yeah, we're assuming that it gets paid off in 2 months. So yeah, potentially the issue of short term arises. Tell me more.
So that's section 6, subsection 1A, which is saying the code doesn't apply if the provision of credit is limited to a total period that doesn't exceed 62 days. So depending on which months we're talking about here, it may not apply on that basis that it's short-term credit.
Yep, nicely done. Yeah, that's not the one that I was thinking of. So that was a good pickup. What else then? Here in the chat, Kathleen has talked about installments. Do you want to tell us more about that one?
I thought installments were now covered under the enhancement, but I may be wrong. I'm not sure.
Yeah. So there's a potential for, if the conditions are right, a sort of payment by installments can apply even if you're not meeting some of those other requirements that we talked about earlier. So it's definitely important to be thinking about where this is a sale by installments, whether that will still apply or not. So we're dealing here with a payment of 2 installments for $5,000 each. So what does that tell us? I'm thinking especially about section 11 of the code. Will I bring it up? So here, section 11, subsection 1. This section applies to a contract for the sale of goods if the amount payable to purchase the goods under the contract is A, payable by installments, and B, exceeds the cash price of the goods. What does that tell us about the act, about the code's application here?
It doesn't exceed the price of the goods.
Yep, absolutely. So here we've got 2 installments of $5,000, so adding up to $10,000, and Tony paid 15 in cash. So 10 is obviously less than 15. So we fall afoul of 11.1b because the installments don't exceed the cash price of the goods. So even if section 11 could apply, it doesn't under these circumstances. So Tony's a bit out
Sorry,
of
I
luck.
want to ask just for understanding there. You said, so it's not the cash price of the good, it's the amount of cash you paid. Or would it be the value of the good?
Well, so it's the same, because it's not, if you're paying, if the installments don't add up to half or more than half, then you haven't paid the cash price. Sorry. So you're asking, is it the 25,000 or the 15,000?
Yeah.
Sorry, yeah. So it's, that's a good question. But the answer is the same, because more than half of the price will be, if the answer is 25, then the 10 is obviously less than half, and the answer is 15. You've paid more than half in cash anyway. So
yeah, I just wondered.
The question though. I'll get back to you on that one.
Okay.
Cash price of goods or services is the lowest price that a cash purchaser might reasonably expected to pay for them. So it's the total price. So 25,000.
Okay, thank you.
Cool. Yep. So either way, it doesn't matter, because it's the half that we're interested in. But yeah, cash price is the full amount, so the 25,000. Any other questions about that one? Cool. So to sort of recap there, Tony is out of luck because he's not bought this as a natural person. He's bought it through his company. Maybe he's bought it for a predominantly personal, domestic or household purpose, but maybe not. We'd have to argue about that one. It doesn't seem like there's been a charge for the credit, and the sale by installments, less than half of the cash price has been by installment. So he fails pretty much every criteria here, which was sort of the point of this problem, was to go through all of the criteria and show, how he fails at pretty much all of them. Are there any questions about, I guess, either of those problems? We're sort of running a bit short this week, which is probably a little bit welcome at this point in the term, unless there's anything that anyone else wanted to talk about. Excellent. Well, that's pretty much all that I wanted to cover, because, if you've been paying attention to I'm choosing my words carefully here. If you've been paying attention to the assessment, you will know that there's probably only so much that I can say about this topic without giving too many things away. So if you've got specific questions about things, please do feel free to email me over the coming week. But other than that, I'm comfortable that everything that needed to be said has been said. And so I'm happy with where things are at. If you guys are happy with where things are at in terms of this tutorial, to end that one here, and let you guys get on with the assessment. But otherwise, if there's things that people do still want to talk about, we can definitely do that now.
So it was just about the purpose for the loan, I guess. If we in the assessment want to pick one angle, should we still talk about the other angle So let's say I decide to go down the route that the lender ought to know what was going on. So we're taking it what we assume the lender knew, not the actual use for the money. Talk about the actual use for the money angle, or
yeah, I can neither confirm nor deny that that's an issue. In the assessment.
it's just
hypothetically,
yeah.
if it was, you would definitely want to, because it's such an unsettled area of law, you would definitely want to consider both sides, or sort of both sets of arguments. You would probably come down on one side rather than the other, and present a compelling reason why that side should be preferred to the other. And that sort of brings us back to the things that we've been talking about in previous weeks about, you know, developing a persuasive legal narrative and really honing your critical analysis skills to help you get to that conclusion and say, you know, this is an area of unsettled law. We should go down this path, and we should go down this path for these very good reasons that I've arrived at because of my critical understanding of the law and that sort of thing. If that was an issue that needed to be talked about in the assessment. Does that make sense?
Yep.
Cool. Any other questions or concerns there? Excellent. Well, we might wrap up and have a little bit of an early mark. Hope you'll have a good week. As I said, best wishes with the assessment, and do get in touch if you need to. Otherwise, we'll be back next week to talk about e-commerce and sort of, you know, the commerce law of the future, which is always an interesting and exciting topic. So I'll see you all then. Thanks very much.
Thank you.